What's up, everybody? Welcome in. Thanks for waiting. I apologize for the technical difficulties and being late, but the internet here at my house is the bane of my existence, and everything was working great. And then now it's not tonight when I went to try to do it. So there will probably be freezes here. I apologize for that. We're going to be watching a lot of the video. So I'll turn my camera off probably for part of it, which hopefully will help. I, again, apologize. I know it's annoying for everybody watching, but plan the stream. It's going to be at least an hour. I want to get through it. I want to talk about it. I want to answer everybody's questions. I thought it was a really interesting hearing. So hit that like button if you guys haven't already. And let's just jump right into it. So the state and the defense both came with different issues they want to talk about during the hearing. The defense wanted to specifically talk about if their experts and their investigators could look into the IgG information, if they could be allowed to be part of the confidentiality and the non-disclosure to look through everything in preparation for the defense. And those are keywords and buzzwords. If you haven't, caught on all the times we've done this, that when you say in preparation of defense and you say we need it in order to provide a fair and competent defense for the defendant, you would think the judge is picking up what they're putting down, that this is a constitutional issue and we need to make sure that everything is protected here. So that's why they kind of give those wink, wink. They do that a few times throughout this hearing, and we'll talk about the other times they do that as well. They talk about they didn't name the investigators, but they will if they need to. The state basically says the experts can look through it, but the investigators don't really need to until the defense talks about why that's necessary. The judge agrees with that, basically. He talks about relevance a little bit more. He knows that the defense has to dig where they have to dig. He allows them to talk to the Kohberger family throughout, but not give them the IgG information. He talks about how is it for the mitigation phase, meaning the penalty phase versus the innocence phase, as the defense calls it, aka the guilt phase. And they discuss that kind of back and forth. And at the end of the day, the judge says experts can look at it. Nobody else at this point. If we need to file a motion to clarify, we can. And the defense said, every time we have to do this, it causes a delay. It causes a problem. Nobody wants to have that delay. Nobody wants to have these problems. So we're going to try to move it along as much as we can. Additionally, the judge asked if the appeal is going to stay these proceedings, because everybody knows at this point they're appealing the grand jury decisions. And everybody said at this point, we're going business as usual. If the Supreme Court wants to stay this case, they will stay it. Then we start to jump into the motion to change venue. Our thought all along is the judge is not going to change venue. At this point, he's going to see if the jurors are actually going to be biased, if it's actually going to be impossible for them to find a fair and impartial jury. At this point, the defense think it is. They're going to call experts. They're going to produce documentation to the state and to the judge to show why, but the state says that's not really the standard. We need to actually show that the jurors involved are going to be fair and biased, not just that they know about the case. The judge said he's been struggling with this decision, and that's kind of where we're going to hop into the hearing now and discuss the judge's ruling and listen to a lot of the argument about change of venue, when we're going to set this case for trial, why we're going to set this case for trial, and the potential options that might come in this Kohberger case as we continue to watch and listen. Yeah, we can talk about Wi-Fi issues more at the end, I guess, if I have the energy. I'm miserable. This is the most miserable thing to me, to watch this and do this. Yes, it's fuzzy. I know people are going to be saying that the whole video, people that just jump on. I'm just going to turn my camera off, and we will continue to talk through it and watch the hearing together.
You're going to wait until it's ready to seating the jury, which is probably a 2-week process in this case. And then figure out, hey, we can't seat a jury, so we have to move the trial. At the same time, how do you really know if there's some prejudice without trying to seat a jury. It's really a catch-22.
And all of the logistical concerns that Ms. Taylor is describing are totally correct. The problem is that is what the law requires, and that is what the case law says. The case law does contemplate that. So certainly it's correct to note that there are going to be logistical challenges to that, but that's what the case law requires. But even if the court weren't inclined to wait until we're actually going through the entire process, at a minimum, I think it would be appropriate for the court to look to some jury questionnaires and at least go through that process.
Okay. This morning I was looking at State versus Haddon, where that was, you're probably very familiar with that, but that's Court of Appeals case, 2012, I believe. And there was a request to change venue well before the trial. The judge denied that. And then it came up again when they were trying to seat the jury, and then the judge denied that at that point. But kind of double step to figure out if it was necessary. I've been struggling with this, and
So the court talks about how, he's struggling with it, and how in other cases they allow them to make the argument now, and then in the future they'll allow them to make the argument again before trial. So like right now, if we already know it's going to be something that needs to be changed venue, then maybe we'll let that happen and then do it again before trial. And I think that's where he's going to end up landing at the end of the day.
It's hard to know. Now, that doesn't mean that one of the parties can't present evidence. And the standard is kind of squishy, in my opinion, but they can provide that kind of information.
Nobody likes a squishy standard.
And, well, before the trial. At the same time, I want to make sure that the state has the opportunity to respond to whatever information Mr. Kohberger is going to present. So now I'm scratching my head about, is May, first week of May, does that allow enough time? Does that allow enough time for you, Ms. Taylor?
Your Honor, I think it does.
So they're discussing when they're actually going to have this first motion to change venue hearing, and they settle on May. I can't remember what day in May, but that's what they end up settling on at the end of the hearing.
I can present the information to the state. I can have my briefing. I can have affidavits and let them know of any witness that I want to call. I can do that probably by the beginning of the second week of April. And that would give them, if we do this in May, that would give them ample time to read it over and respond to what we intend to present.
Thank you. Ms. Beatty, what are your thoughts?
Your Honor, as far as the duration of time between the briefing and the hearing, the state has no concerns about that. The state would just have concerns about those factors that the courts require us to look to a trial. But as far as a briefing schedule prior to the hearing itself, that timeline makes sense to the state.
Well, let's explore that just for a moment, because I've been thinking about setting a trial. Also for months, but I listened very carefully to Ms. Taylor and Mr. Thompson in our last hearing, and I really, it wasn't clear that I'm not really happy about setting the trial in 2025. It seems so.
And that's kind of a common theme. He does not want to kick this case out. And the big question for this hearing is, it seems like everybody else kind of is on the same page that summer of 2025 would be best for the college, for the surrounding areas, for the time it's going to take for trial. Initially, the state was pushing for summer of 2024. More on that in a minute. And the earliest the defense said in the past that they could be ready is March of 2025. So we're going to start getting into the scheduling of the trial, where the issues are, and where we think it's going to come down at the end of the day, because he does not make a decision today, but he definitely gives us a little bit of an idea, and like judges often do, tip the cap a little bit about what they're going to do. Shows their hand, you can say.
So far away. Now, it's not just, doesn't just affect Mr. Kohberger and his defense, but there's a lot of other considerations. So I am trying to be fair and realistic, okay, about when we could really be ready for the trial. Now we want to do it once, okay? So let me go first to you, Mr. Thompson, about when. I know that it's been complicated, the discovery. I mean, you have these different agencies, FBI, state police, the state lab. We've got Moscow Police Department, Latah County, Pullman law enforcement, Pennsylvania law enforcement. And I think you mentioned it's hard to get all this stuff together. And that is one of the things that has delayed setting the trial, not to mention the motions about the grand jury procedures, also the issues about the investigative genetic genealogy issues. And I'm kind of curious, okay, when do you think that you will be completely finished with providing discovery to the defense?
So he asks the state, when do you think you'll actually finish providing discovery to the defense? Meaning they haven't provided it all, right? We've heard a bunch of times they have everything. They have everything we have, Judge. And you heard the judge go through the IGG, the experts, the investigators, the 400 witnesses the defense has talked about calling, talking about the car and the security cameras and the DNA. Tons of stuff has to happen in this case, and they haven't even started talking about death penalty, mitigation phase, things like that. And when we get to that, you'll see this is so complicated. This is so complicated. There's so much to do. There's no way it could have ever been done in summer of 2024. I'm not saying, by the way, that I didn't want it to happen in summer 24, or I think I want it to happen in summer of 25. I was always talking about what I think logically is possible. And I always thought summer of 25 was the first realistic date we could start this trial. Now, is that what day he's going to set? I have no idea. I'm not the judge. I'm just talking about knowing how this stuff goes, knowing how easy it is to delay cases. One issue can create a major problem for the defense and delay the case even more. But let's listen to when the state says they believe that the state believes they're going to finish giving the discovery to the defense.
Judge, most current projection that we have would probably be at the end of the summer. The majority of the...
So the state thinks they're going to finish giving discovery to the defense by the end of this summer. Wait a second, Mr. Thompson. Wait a second. How is this possible that you are going to give the discovery to the defense at the end of the summer when you thought that this case was going to go to trial that summer? How does that work? Please explain that to me. And the judge is going to ask that question.
discovery has been provided. That's not to say that Mr. Kohberger has been able to, and his defense team been able to digest it all, because it is substantial as an understatement. We are still awaiting information that the defense both wants and needs to have. And we're going back through all of this discovery to make sure that nothing's been overlooked. We have 2 members of our team, attorney and legal assistant, who are essentially assigned full time to that task. And that's projected. We got them. It could be up to 6 months, which would put us with initial discovery completion at the end of August, 1st of September of this year.
Because last time you were talking about August for the trial.
Sure enough. And that's what we hoped for. And when we filed our motion for trial study scheduler back in December, a couple months ago, we felt that was realistic. And as we are looking at where we are right now, I'm not sure that it is. We know that the defense has already indicated just on the death penalty alone, we'll be filing multiple motions, and they've been very lengthy. We've seen the same filings in the Nez Perce County homicide case that recently resolved.
So again, they start to bring up the fact that they know the defense is going to file multiple motions on the death penalty part of it.
I see taking a couple months in and of themselves to address. In addition to motions that actually directly relate to the merits of this trial, discovery, motions of limine, and that sort of thing. Our team met again this morning with our companions from the AG's office here in Moscow, and we actually have a proposal to make to the court for a trial date and a scheduling order, if Your Honor is interested.
I'm very interested. I'll tell you before you say anything about that.
Yes,
I was looking at whether or not it was realistic and fair. Okay, being trying to be compromising to some degree. I think it was March 3rd, 2025.
Well, Your Honor, just happens to be in pink highlight on my pad here, March 3rd, 2025 for trial.
Okay,
So there you go. It's almost like they're on the same wavelength, right? The state and the judge both had March 3rd, 2025. Where do you think they got that date? Where do you think they got that date? Well, it was the date Ann Taylor said, if everything goes perfectly, that is the first time I feel like I could be ready for that trial. So of course, the two sides that want to move this along pick that date. But it sounds like if you ask Ann Taylor, things are already not going perfectly. So is that something that's going to happen? Probably not, but it seems like that's when the judge wants to set the trial. And what I was saying is, I think that, oh shoot. My computer just said it's going to reset in 55 seconds. Hopefully that doesn't happen. If they do that, then I think it sets up a little bit of a wiggle room for them to continue the case at some point as well.
No idea. I wasn't reading your mind or anything, but I thought that's about the mid. And I remember, Ms. Taylor, that you said that would be the soonest you could be ready.
And that was if everything went right from that point.
And I remember that
And
too.
it hasn't, but I'll hear what their proposals are.
Okay. Go ahead, Mr. Thompson.
Thank you, Judge. So we would propose that the court set March 3rd of 2025 as the start of trial. We would propose a September 6th, 2024 preliminary discovery deadline that would include exhibits known at that time. November 8th, 2024 for the defendant's discovery deadline. That would give them a chance to respond to any last minute discovery that comes out from the state. February 7th of 2025 for the state to disclose any basically reply or rebuttal to what we learned from the defense discovery. That would include rebuttal experts. The defense's deadline would also necessarily have to include their mitigation evidence. We would suggest the court consider a final pretrial conference, kind of the pretrial wrap-up details conference for the week of February 12th to 16th, 2025. Since the death penalty related motions are already known and they aren't dependent on discovery, we would ask that any death penalty related motions defense have be filed by September 6th of this year. That the state have until October 11th to respond. The defense can then reply by October 25th and schedule a hearing during the week of November 4th through the 8th of this year. So we can get that wad of 12, 18, however many of those motions are going to be filed, we can get that handled. We would suggest that the court direct the jury questionnaires, if we can't agree on one, that the directed suggestions from the state and the defense be to the court by November 1st of this year. That would give the court the opportunity to finalize a jury questionnaire that the court is comfortable with, and it can be ready at the start of the next calendar year, which is when the next jury pool would be polled or would be drawn. And the court can, at that point, get questionnaires out to an initial panel and can assess in a timely fashion, are we really going to have venue issues in the early part of next year as we approach March 3rd. We propose that during trial.
So it's a plausible timeline. There's nothing wrong with that timeline. If in fact the defense can be ready by March 3rd, the defense is going to quibble a little bit, but at the end of the day, the defense is like, I don't think we should pick March 3rd. I think we should pick June of 2025. That's the most plausible time for us to have this trial.
Instructions, exhibit lists be exchanged by January 31st of 2025. And finally, as to pretrial motions, which would be case-specific motions in limine, those sorts of things, the deadline for filing, that would be November 22nd of this year, with the understanding that parties can file them early. And the state already has been developing a list of various pretrial motions in limine that we think we'd like the court to consider, and we can file those early. But the deadline be November 22nd, responses by December 13th, replies by December 20th, and then schedule a hearing on any of those pretrial motions sometime during the week of January 6th through the 10th. And I think
You have to write that down.
I have it all written down.
Let's start.
Yes, sir. And we can get it to you in writing. That's not a problem.
Okay. Ms. Taylor, so if things aren't going perfectly, of course they never do.
They never do, Judge. They never do. And I'll say it again.
Everybody knows that. Every lawyer knows that. Every judge knows that. Never does a case go perfectly. The case is not going to go perfectly. So I could also fault Ann Taylor, right? I could also fault Ann Taylor here, not just the judge in the state, because she's the one that said March, right? She said March. She threw that date out into the universe, and that's the date now that they're all picking, because she said it was maybe possible to go on that date if everything went perfectly. So you can't blame them for picking the day. It's kind of like when I'm in a mediation and the defense attorney gives me a bracket, I only hear the top number. I don't hear the bottom number. I sure as heck don't hear the middle number. I just hear the top number. So when you tell them an early date, that's the date they're going to hear. That's the date they're going to want. And that's what they're trying to push towards.
Death is different. This is a capital case. I've heard the court say the court only wants to do it once. I've heard the court ask.
So now she's going to go through and give a little lesson on how complicated this is and how much work this is.
What can I do to speed things up? I need discovery. I need all of the discovery. I need the things that we've asked for. I need to not have to fight in motions to compel for things that was done on behalf of the state by the FBI that ends up being used against Brian or used in the investigation. I need that stuff. I need, when I ask for something, I need to get it rather than have to go back and ask and ask and ask again. And I'm not saying anything.
So this is funny because I know a lot of people aren't going to like that and think that she's annoying and stuff like that, especially because of who she represents or whatever. I've literally been saying this from the jump. If the state doesn't want delays, if the state wanted this case tried within the speedy trial period, they would not have fought certain things. Now, certain things are not admissible. State should fight them, all that. But the defense has won so many motions to compel because the state is not appropriately trying to block certain evidence that either they know or should know is going to come in and should have just turned it over to not cause delays. But Ann Taylor's right. They've had to ask multiple times. They've had to file a motion to compel, and the motions to compel, they've won a lot of times. And they're going to, I mean, both sides are going to admit at this point that the FBI has said certain things don't exist. And then guess what? Eventually they do exist. So when that starts happening, the defense is going to continue to hammer away at the fact that this is our constitutional right to a fair trial. You guys are blowing it by not turning things over. And she's going to say it's not Bill Thompson's fault. It's not Bill Thompson's fault at all. It's mostly the FBI's fault. But either way, Brian Kohberger needs this information, and he needs it now.
About Bill Thompson. I'm just not. I think he tries his very best, but I think he's hampered by the agencies and the information he gets from them. I can give you some examples. We asked for x-rays. We were told they don't exist. They're listed repeatedly in reports. We asked for them again. And I'm not sure if I'm getting them or not. The response is we have thumbnails, but we haven't found the actual x-rays. There's one example. I asked for certain mapping data done by a member of the CAS team. They said, you have it all. I said, no, I don't. I only have November 29th. They said, oh, well, I guess we just didn't get that. Something didn't copyright. And I'm not saying anything mean about.
So, and then it appeared. And Thompson's even going to agree that, you know, the first times they said, we sent the pictures, but it was just the little bitty thumbnails. You couldn't actually click them and look at the pictures. So then eventually, after asking and more time goes by, they actually have the pictures. So then they talk about some mapping data and they're like, we don't have it. They're like, yeah, we did. We turned it over. Oh, somebody must have copied something wrong. And here you go. Here you actually do have it. So now we'll turn it over to you. And those delays, they do add up. I know it's frustrating, but they do add up.
Bill or his office. I'm saying this is really difficult to drag the information out and get it to my experts or to understand it. And to hear that we're going to have a discovery deadline by the end of August is great. I need to have every piece of everything. I then have to have time to double check and make sure I really got it. I need to have time to give it to my experts and for them to have an opportunity to understand how that impacts their opinions, if at all. So I'm prepared for this case. And then we need time to get things to the state and for them to respond to what we send to them too. I know that this court wants to set this trial. These kinds of cases don't happen in a year. They don't happen in 2 years. They take a long time. This case is challenged with the way discovery has come at us. I'll give you another example. I open up, I get them and I list them in my computer by date. At one point, I gave the court a printout of that so the court could see how I'm getting it.
This is a cool explanation too that kind of puts you in her mind a little bit. People are asking about the x-rays. Yeah, it's the x-rays from the autopsies. So why does the FBI suck? It's not that they suck, but they're the FBI and you can't tell them what to do and you can't force them to do something. And if they say it doesn't exist, then it doesn't exist. And this is not abnormal. This does happen in cases. What is the problem with giving the defense everything they have? So you never want to just give them everything you have if it's inappropriate or inadmissible or irrelevant, things like that, not reasonably believed to lead to discoverable material. And to me, so much of what is tried to be blocked in discovery, the other side knows they're going to have to turn it over. They're just causing a delay. Tom said, Peter, content is king. The tech issues will work out. Keep it up, my man. Fun fact, Azam taught me, thank you in my 51st language, Tarima Kasi. I'm probably not saying that right. Tom, I know. And we bought 1,000 different things, upgraded the internet to like the best business class, whatever, had them come back out. They redid a bunch of wires and all this stuff, and it still doesn't work. So I'm going to have to switch internet companies and try that. It's so stinking frustrating. So annoying. I hate it. All right. So now Ann Taylor is going to give us a lesson into how she finds discovery and figures out what she needs next. And you ever wonder, like, how do defense attorneys know that something exists when the FBI says it doesn't exist? How do we? Somebody's got to be right. Somebody's got to be wrong.
And when I look in a folder, it has subfolders. And I might get some reports from Moscow Police Department with an FBI report. And an FBI report might reference an email. It might reference a photograph. It might reference a screenshot of a picture or of a phone that they took when they interviewed somebody. That's not with it. So maybe a few months later, I get some photos that has these screenshots in. And now I have to try to figure out who gave that screenshot, whose phone did that come from, which officer did that interview, and get them matched up and figure out that somebody I need to talk to. So not only do we have a huge volume of information, the way I get it is completely disorganized. And it's like if you wanted to play 52 card pickup with 100,000 decks of cards and throw them in the air, and I have to go figure out how to put them together. And by the way, the backs of every one of those cards look the same. That's what I'm doing.
So that's how. Something is mentioned in an interview. A screenshot is mentioned in a phone data dump, but the screenshot is not included. So they say, we know the screenshot exists. an interview is mentioned or referenced that I lined it up with this interview and it didn't make sense. Like, but we don't have that interview. They're like, well, that interview doesn't exist. Well, then how is it referenced in this report if it doesn't exist? So when defense attorneys go through things and they dig and they work through discovery, that's how they figure out who their witnesses are. That's how we figure out in civil cases too, how to ask for certain things, what exists, who do we need to talk to, what do we need to ask for? Because so many times you pick it out and you find it, maybe going through one thing and figure out you need 3 more things just by reading this one document, or you need to talk to 5 more people after taking the deposition of one person. So that's also really important in how it all works. And I thought she did a good job of explaining it right there.
We have science questions in this case. We have DNA. We have cell phone analysis. We have video analysis. The video analysis that the state really likes in this case, I don't have the full scope of that video with audio that should be available. They're working on it. They really are. I don't think they're not working on it. I'm just saying this is a real thing that takes time. And then
So I am not saying at all that Thompson lied. In fact, the defense said she doesn't blame Thompson. It's the FBI for the most part that's either just wrong or misleading or thinks they did something that they ended up not doing. Nirvana said Idaho can't afford 2 capital cases in 1 year. So Lori Vallow wasn't technically a capital case. We'll see if Chad Daybell's trial goes this year because they're trying to delay it too. But eventually these cases are going to have to go to trial.
have the public nature of this case, and people don't want to talk to us. They're not willing to talk to us. So we have to try to get witnesses, people that are listed in the state's discovery, to talk to us. We have our duties that are required with mitigation because there's no break. I don't get to go to trial on the innocence phase, and then if something goes wrong and Brian's not acquitted, I don't get time to go prepare that mitigation. I have to take another breath and start right there. So I have to have time to do all of that. Our mitigation expert is working as quickly as she can. She is meeting a lot of
Yes, she did say if something goes wrong and Brian is not acquitted, showing confidence in her position.
resistance to collect records and to conduct interviews. We're working through that as best we can. She has travel obligations to try to interview people. These things take time. I want the discovery by the end of August. I love the discovery deadline by September 6th. That does not allow me enough time to get ready for trial by March 3rd. That deadline, that cutoff for us to get mitigation materials, that's impossible. That's just impossible. We've got the year pretty well scheduled out with what travel still needs to happen and what records still need to be obtained. So to have that to the state, I think they said by September, October, that's just impossible. I would request that this court take up our venue motion in May, make a decision on venue, and let's see where we can get with the discovery. I still need to read every bit of discovery that's come, and I haven't. I scan it when I get it, but to go page by page and read it and understand what it means, I'm not through 2023. I have a long ways to go. So I don't think that is realistic to set it. I think if you set it for March, I'm going to be back here after the discovery deadline, and I'm going to be telling you there's no way that we're going to be ready for trial. I would rather this court set the change of venue, make that determination. Let's see where we get with the discovery by May. Probably the court would have a decision by the end of May, early June. Let's see where we are with discovery by then and set a realistic day.
So Ann Taylor wants to kick the can a little bit. And honestly, it's not a big deal if we're looking at March of 25 or June of 25. Kicking this decision to May is not a big deal. It's not like we're going to kick it even further out or she's going to ask to be kicked further out unless, of course, she continues to not get discovery and there continues to be problems outside of her control. Chris said, warning, office floor may have spikes. Enter at your own risk, Peter. Thanks for everything. Even if your office has a spike floor. Luckily, it doesn't. It was just a little analogy. So everybody can safely walk through my office. Purple Dinosaur said, finally made a live since starting my new job, waiting for Netwoman to adopt me so I can watch more live Lawyer You Knows.
hope we can go by summer of 2023.
Well, thank you, Ms. Taylor. I can help in any way to speed things with, if there's problems with discovery, I'm happy to do that on very short notice. Just so that we can.
So he's saying if you need to file a motion to compel, you can file it and I'll let you get in, unlike Peter Tragos's cases in civil court that take forever. I'll get you right in on these kind of cases. And criminal cases, death penalty cases always do take precedent. The problem is, though, if you get to the point where you've got to file a motion to compel and ask the court, usually you have to wait 30-ish days and maybe give them an extension to give you that discovery. Then you got to send a 10-day letter saying you didn't send the discovery I asked for, not all of it. Then you have to confer with counsel to set a motion to compel. There are all sorts of delays. Now, it doesn't seem like either side wants to delay, and it can be really frustrating when the state's like, we want to give you this, they won't give it to us. So I don't know what to say. Get a court order, I guess. And then again, delays.
Keep going. But you say, it'd be fantastic if You got all the discovery by August. Your mitigation has been okay already, right? And just to know that I'm not being insensitive about this, I did read the ABA supplementary guidelines for mitigation function of defense teams in death penalty cases, and it's huge. Okay, I get it.
So he's talking about how much work defense teams have to do in death penalty cases, and he's going to give a little synopsis here again. Multiple times throughout this hearing, everybody agrees there's a ton of work to be done. So to rush it is just not a good idea.
Are so many things that if you don't do, then it comes back as, well, you were ineffective. And those standards are high standards for sure. And obviously it takes a lot of time. So, but I'm also thinking, if you get all the discovery, if you can, assuming that, which may be inaccurate, by the end of August, you're saying that you wouldn't be able to respond to all of that, assuming that it's even earlier, that you could not be ready for the beginning of March 2025.
That's exactly what I'm saying. I'm saying I love that discovery deadline. Let's shoot for that. And I think that would help me make a June 2025 trial. I think once we have that discovery, and I agree, we can.
They keep saying March 25. She keeps saying June 25 now. James said, when will the defense receive all discovery? It seems like by the end of August. But I think they say later, the state says they've given them like 95% of it already. So maybe sooner. It's only February. So maybe, I don't know why 6 months. It's going to take you 6 months to get 5% of the discovery. That doesn't make much sense either.
File the challenges to the death penalty earlier, but the challenges to some of the things that are going to be contained in discovery, those we need to see it all and see how it interplays. I can do some things early, but I may be coming back and asking the court to reconsider if it doesn't go our way and we found something that we didn't have. I think a discovery cutoff is great, and I think the court has to manage that discovery. If we finally are up to the eve of trial and there ends up being a whole new dump of discovery, then the court has to look at that discovery and understand, is it exculpatory? Is it something that we didn't have a chance to prepare for? It should be excluded. If it relates to anything to do with the death penalty portion of the case, then the court's going to be asked to strike the death penalty. I mean, the discovery deadline is critical in this case. So I love that. I love that. What that means, if I have all the discovery by the end of August this year, it means that there is a stopping point where I can know I have it all. So I can confidently get the motions filed. I can confidently tell my experts, this is it. This is the scope of what you have to do. And I can have some space to read it all and understand it and get ready for witnesses too. If the court makes that deadline, know that mitigation is not going to be done by then. But if the court makes that discovery deadline, and then we follow that with our motion practice, and then our deadlines for expert disclosures and whatever's going to come from that, and our mitigation, we should be in good shape by June of 2025 to try the case. If we have that discovery.
And again, now she's saying we should be ready by June of 2025. Rebecca said, no worries, Peter, life has technical issues. I don't know why it bothers me so much, but it is so annoying. It's so annoying. You guys be watching anything, right? Why would you ever want to watch something that's freezing all the time? That would bother me, so I totally get it. Jerry, off topic, but today's our 25th wedding anniversary and still in love. Jerry, congratulations. Some good news here in a frustrating night for me. I hope to make it to 25 years in 11 years. We're on 14 years, almost 14 years. Peggy, if the room has a metal door that can cause problems with the internet, some types of insulation can also mess up internet reception. Some remodeling may be needed, but been there, done that, sending hugs. Thank you, Peggy. We are plugged directly in to the internet, and it is on the wall right here where I'm at. So it is about as frustrating and mind-boggling as you could ever imagine. Brianna, does the University of Idaho have a say when the trial begins, summer, fall semester? No. They are not victims. They are not parties to the case. They really don't have a say. Now, both sides are being respectful of the community, of the university, of the people. I get it. They are, but they don't really have a say, per se.
That's a great idea.
We can say with Mr. Thompson.
Trying to figure out where to start first. Yes, discovery is fast. Yes, there have been things that Mr. Kohberger has asked for that we've inquired, and we were initially told, no, we don't have that. And then we have gone back at the prompting of defense. You sure? I mean, it ought to be there. And for example, x-rays for the autopsy. Well, we just got those. The first came in with thumbnails. In today's discovery, Ms. Taylor's going to have the full size, which we were able to obtain. We saw he gave us thumbnails. These are useless. Give us the real thing. And through the coroner's office, we were able to finally achieve that. According to Ms. Jennings, we are better than 95.
He even said, FBI, said it didn't exist. We go back and are you sure? And then voila, there it is. And that's where he just said we gave her 95% of the discovery so far.
Percent complete on discovery. So we're getting close. There are some things that are outstanding. There are some issues with what information is actually available to us. We have given Mr. Kohberger everything that we haven't asked for a protective order on or had some sort of dispute about. We've given it to them, and frankly, in the orders come in, instead of waiting to try to package it together and give it to them in a different format, just because they want it as quickly as possible. And I appreciate that. And we're going to continue doing that. It's going to benefit to have deadlines for everybody to have to work for here. I don't think just setting a deadline for states discovery does anything other productive other than that initial stage. So if we're going to set discovery deadlines, we need a state's discovery deadline. We need a defense discovery deadline within a reasonable time after that and a reasonable time before trial, because we're going to then have to investigate whatever the defense tells us they might be using. And then, of course, an opportunity after we see what the defense is proposing or is disclosing to rebut that in some fashion and give notice of that. So that package of 3 days are important. Pre-trial motion on the death penalty, I think that's important. We need deadlines, so just get it done and over with. And those teams can prioritize based on the timelines what needs to be done when. I don't know the first thing about what's going on with defense mitigation. Apparently it's been going on for a while. It sounds like it's going to be massive. That's something that we just don't have any insight to. We think that our proposals are realistic. We appreciate the fact that something could happen where it turns out that they aren't realistic, that something happens and we have to revisit. And I think we need to be prepared to do that. I think the last thing that I want to touch on real quick is the proposal to set a state's discovery deadline and set hearings on the change of venue is inadequate. As we've indicated, the change of venue under the law, that motion is premature. We need to be able to give the court the benefit of what impacts.
So I summarized what they argued earlier, but they kind of go through it again here. So we'll get to listen to it again. Shannon asked if the trial will be for all 4 students simultaneously or 4 trials. They will all 4 happen at once. My kid's personal Uber driver asked, what happens if he's not guilty? He sits in jail the whole time, right? Does BK get anything from all the jail time? I've always wondered. This is a question a lot of people have. And unfortunately, the answer is if you're not guilty, if you're acquitted, you get to go home, but you don't get anything for sitting in jail. And the reason for that is at this point, multiple people, a grand jury, a judge, law enforcement, state attorney's office have found that there is probable cause for your arrest. There's enough evidence against you, try the case against you. And that's how the system works. And in order to do that, that's how you arrest people. That's how you get them through the process. That's how you convict the guilty people. But when crimes are heinous and they have a lot of evidence against you and they believe they're going to convict you, in certain circumstances like Brian Kohberger's, you sit in jail waiting for trial. And sometimes it ends up being not guilty. But if there's no fraud or nobody lied to put you there or did anything horrible to put you there just to hurt you, there's no real legal recourse. You don't get money for getting a not guilty verdict. Gringa, is it common for defense attorneys to demand more time under the threat of being ineffective? Absolutely. It is their most common threat. That if you don't give me more time to do X, Y, or Z, I'm going to be ineffective. We've seen it in Lori Val or in Chad Daybell's case as well. What is the point of mitigation? Ashley asked. If he did what he's accused of, there's no way getting around the death penalty. People said that about Nicholas Cruz here in Florida as well. But sometimes there's enough mitigation to get life instead of death, even if you're convicted of the most heinous crimes.
Publicity, for example, is happening on our actual jury pool. We know there's publicity. Everybody can agree. There's been massive publicity, not just in Wayne County, but I see more about it in Boise or hear about it from other parts of the state and what we're seeing locally. And so the massive publicity, that's a red herring, realistically. There's publicity everywhere about this.
It's not quite a red herring, but he is right. Just hearing about the case does not disqualify you to be a juror.
The publicity and the nature of this case is such that we cannot pick a fair and impartial jury in this county. And of course, we know that just being aware of publicity about a case does not disqualify a juror. There has to be a showing that that publicity or whatever has impacted the juror to the point where that juror cannot sit in this box as a fair and impartial juror and make a decision based only on the evidence presented in this courtroom. That's the issue that Your Honor is going to have to decide on the change of venue question. And you can't do that based on a bunch of affidavits from experts who say, Judge, there's been a lot of publicity. That doesn't cut it. So I think just having a state's discovery deadline and trying to prematurely move forward with motion for change of venue is not the right approach. We think that the proposals that we've made are reasonable, understanding Ms. Taylor has concerns about whether she's going to be able to meet those. And I think there are enough stages in there that if that becomes a reality, there's the opportunity for us to discuss that. Like everybody here, we only want to do this once. We do not want to invite error that we can avoid. Thank you.
Thank you, Mr. Thompson. I think you said maybe you're like 98%.
But probably a little more than 95%. It's what Ms. Jennings just told me.
Okay. So if it's 95%, I mean, is it possible that it could be done before the end of August?
It's possible, and we aren't going to wait till the end of August to do anything. We will continue to disclose information as we receive it. I mean, that's not fair to the defense. That's not fair to anybody. Just sit on stuff and dump it. So we are hopeful that it'll be finished by then, but we don't want to have to face a deadline that we think there's a chance could be difficult to meet. And that's why we propose the early September date, which would be essentially 6 months from now.
September 6th, that's what you're saying?
Yes, sir.
Ms. Taylor, you said that would be fantastic.
That would be fantastic, Your Honor. And Your Honor can give us a January 2025 deadline if the court wants to set a discovery deadline for us too. Expert disclosures, I think maybe would take a little bit longer, maybe February 2025. The court gives us a deadline for expert disclosures. I want to comment on the motion for venue change. Your Honor, because I filed a motion and the court doesn't have affidavits or the briefing to understand how we're going to approach this, doesn't make it untimely. I'm fully aware that the massive amount of media coverage by itself isn't all of it. But I'm also aware that this case has had more media coverage than most other cases, and it continues. So there is an impact of that. There are other considerations besides just the massive amount of media and an impact on potential jurors. That's what we're going to talk about. I think it's timely. I think it's appropriate to set a change of venue motion. I think it is what makes the most sense for the court to make that determination and set a trial date from there. If the court sets one here and has to change it later, a lot of things have gone into play to get that trial date set here, to get the courtroom reserved, and a lot of people realize that. Waiting until the court has heard the information, more than affidavits saying there's a massive amount of media coverage, the court can make that determination. If the court agrees to change venue at that time, then it makes a lot more sense to just set that trial from there. I would think by the end of, or by May, when we can have a hearing, I would think I would have a better handle maybe on the process the state's going through now with its discovery. I will continue to make that most effort to get all the way through every piece of what I have now and continue to follow up with questions to the state so that we can try to have this discovery issue put aside.
Ocean Soul asked, would new future discovery impact the trial date as well? It could. And here's a way that it could. If the state produces something new and the defense is like, oh, crap, we need another expert now for this, judge. So we have to look for, retain, pay, get the expert this information, maybe do a deposition, get them ready for trial. So new discovery could create new delays and new issues. That's why we need to get all the discovery done. Now, one thing here, one little thing there, a different witness that's going to testify to the same thing. We picked this fact witness instead of that one, something that doesn't really change anything, maybe not that big of a deal. But if they're going to, give the pictures to their expert of the autopsy to show that it had to be two people or it was multiple weapons that were used or things like that could be really important. And they need to have time to do that. Julie said red herring. I think she means herring. Papa Rogers used that phrase. This is an incredibly common phrase in the legal field, a red herring. So I wouldn't pick up.
Once we have the discovery completed, I think that we're going to have a lot better idea of what the motion practice is going to look like and how long that's going to take. And it'll be a more realistic way to disclose experts to one another with the materials that's required under Idaho Rule of Evidence 702. I think that's a better way to go, even though you might not set a trial date today, because at least you'll set one that's really informed that maybe everybody can rely on.
Thank you. Well, I'm gonna make an informed decision about changing venue, and it makes sense to me. I mean, it may be premature, but I'd like to see what the defense has to say about that, what you're going to present. So, as I was curious, I can always deny it, but if it's sufficiently strong and persuasive, then maybe it makes sense to do that. Obviously, for personal reasons, I particularly want to go to another county.
He's like, selfishly, I really don't want to go have to drive to another county to have this trial. And a lot of people are asking, will he stay on the case? Yes, they'll just have the trial somewhere else. They'll do all the hearings and stuff here still. But it sounds like he is going to hear at least a motion hearing on the change of venue before making the final decision. And even if he denies it, then he'll probably allow the defense to do it later as well.
Well, weeks, 13 weeks, necessary. I mean, we'll do what we need to do, but I'm not, as I sit here, I'm not persuaded that we necessarily have to change it. I think that's important. There are a lot of factors, and that's one of the reasons why I was looking at this patent case, which is that's court of appeals, but it goes through all of the other cases that have dealt with this issue. So I'm thinking, you said mid-April that you would be able to file all of your declarations, affidavits, whatever you're going to do. Let the state know that who is going to testify. If you're going to have witnesses to testify, there's going to be experts. We got a taste of that, sometime at the beginning of one of our hearings. So maybe I'll hear the same witness. I don't know, but
He's like, we've already gotten a taste of some of the experts, and frankly, they won the day for the defense. Lady Los Angeles said, given the judge's initial reluctance, what specific arguments would be most persuasive to secure a change of venue? It's not just the judge's reluctance, it's basically the case law's reluctance. It's very unusual to change venue. In some of the craziest cases, like Derek Chauvin's case, they didn't change venue. Lots of cases where you may think they're going to change venue and they don't. The really specific, most persuasive evidence in a change of venue is what we saw in Murdoch, and what I believe, oh, John just hit something. On Murdoch, what I believe during the financial trials that never ended up happening, where his team provided questionnaire answers from prospective jurors that say, I'm biased. I already know that he did it. I couldn't sit on the jury. That's the most specific and persuasive evidence that you can get, is prospective jurors that can't be fair and unbiased in this county, so they need to go somewhere else where it's not at the forefront of everybody's mind. How could the defense have 400 witnesses? Honestly, Patty, I have no clue. I have no clue. Thank you, Carter, for gifting 5 memberships.
So we'll say April 17th,
Yes, I can make
Okay.
it.
and maybe we say the state has enough time to have their response by May 1st. What do you think?
That's-
Okay,
I think that's appropriate, Your Honor. Thank you.
okay. Because there may be experts on the other side too. So, and I expect the information that you're going to present both sides and with the brief. So obviously. And I'm going to be in Boise the next week. We actually have other cases. Be surprised.
I'm going to skip here while he's.
Afternoon of May 20th. That's a little bit far out, but we've
Oh, they're going to do the change of venue hearing the afternoon of May 20th.
already been talking about maybe having a trial starting in June. So
Your Honor, can I have it before May 25th? The witness I anticipate is not going to be available starting May 25th.
May 20th.
Maybe they picked May 13th. I can't remember.
Time is 80. How about 1:30?
Sounds great, Your Honor.
So 1:30, May 14th.
May 14th. Okay.
I am going to,
And before we get to his next decision, a couple questions here. Charlie said, is it unusual for a public defender to get a raise for representing a certain client? Seems wrong. I mean, yeah, it's unusual, but it's not unusual for them to allow more money to represent certain people or certain cases that require more resources. And that's more of what it is than her getting a raise for this case. Concur said, do you think this judge is able to be fair? Absolutely. I don't think he's been unfair. I think he's weighed things appropriately and done a good job on this case from my perspective. How would you determine whether a juror is actually biased? Well, Kayla, sometimes they'll tell you. They'll say, I've watched these documentaries. I know Brian Kohberger did it. Or I believe one of these other theories that it was this person. I don't think he did it. One side or the other starts out way ahead or way behind. They'll tell you sometimes if they're biased and can't be fair.
make a determination about that presentation on change of venue before I set the trial. It could still be March 3rd, or maybe beginning of. Yeah, that's 2024. I know. I'm just still thinking of 2024. But it's hard. It is hard to think it. It's so far out. But I'm listening carefully.
He really doesn't want to push this case that far out. And thank you, Rebecca. As soon as this is over, I will. This was the last thing I had on my list of things to do today. Check the box and be done. I really want to talk about it. I thought it was a really interesting hearing personally. And my kids are in bed, so I'll go hang out with my wife as soon as this is over.
Fully to both sides, and it's a complicated case, and it's a death penalty case, and that adds a lot of it really does. So I'm gonna hold. I would like you to send me your scheduling list, and I will think about that. We're going to have a deadline of September 6th for discovery from the state. And Ms. Taylor, did you say beginning of January?
Yes.
Okay, January. Give me a date.
9th.
9th. Okay, good job. All right, and that'll be 2025. Ms. Beatty.
Could we address one more deadline briefly?
Yes, of course. You all give me deadlines. I'll write them down.
Thank you, Your Honor. There's been an ongoing discussion beginning most recently with the state's request for scheduling order, and I believe Ms. Taylor briefly addressed it at the last hearing. There's been an ongoing discussion about the alibi deadline.
All right, alibi. A lot of people's favorite topic to discuss. Brian Kohberger's alibi. How is this thing not done? I thought the statutory deadline passed so long ago. And I told you guys, just like I'll tell you now, and the judge is going to set another deadline here. If something comes up that is exculpatory, that is an alibi, I find it very hard to believe that they're going to strike it. Now, is it likely to come up after the deadline? No, but we're going to listen to them argue about it a little bit more.
And the state is asking the court to either limit the defendant to presenting evidence about the disclosure that he made related to the alibi, which was that he was driving around the night of the homicides, but not allowing any further discussion or evidence of an alibi, given the amount of time that has passed since the state requested that alibi disclosure. Alternatively, since it was in the court's scheduling order initially prior to the trial being vacated, we would ask the court to set a 10-day deadline now, because that is consistent with the alibi statute. The state does not believe it is appropriate to tie the alibi to a jury trial date in this case. The statute that sets forth that 10-day timeline is completely separate from Rule 16 and other discovery deadlines through the litigation process. I think at this point, there's been so much time that has passed, and it has frankly causes the state great alarm that the defense is discussing calling upwards of 400 witnesses during the innocence phase when we don't have, potentially don't have a full alibi disclosure. And when you look at,
I gotta be honest, I get that it causes you concern, but it's like you can't say no to that. If it's reasonable and they need those 400 witnesses, the state is very weirdly scared about this alibi defense. I don't get that. There's not a lot of cases that I've seen the state fight this much about the alibi, because they know if something pops up the day before trial where there's a video of Brian Kohberger driving around, they're going to get to enter it. If they can tell the court, there was no way we could have had this, judge, a good Samaritan just gave it to us, and it's a Wendy's drive-through that Brian Kohberger drove across the street and it picked it up, and we didn't find out about it till today, and we can authenticate it. That's coming in. I don't care what the deadline is. It's just very weird.
Cases regarding appeals from issues that arise during alibis that come up at trial. These cases are all defendants appealing a conviction because the state doesn't get a second chance. If the state gets ambushed at trial, that's it for us. We're asking the court to hold the defendant to a fair alibi deadline, and I think that the time has come. Thank you, Your Honor.
Well, my understanding was that was it, but I may be wrong. Ms. Taylor.
No. When the court vacated the trial setting, the court vacated all of the deadlines, including the alibi deadline. That wasn't carved out as one that was still.
She's right, technically. Now, the court might not have meant to do that, but all the deadlines were basically gone when speedy trial was over and things like that, even though this one is already a statutory deadline. So technically it did pass. But regardless, Ann Taylor's like, we still have the deadline open. And it's weird the way that they're discussing it too. It's like, what evidence do you think you're going to find? Or what is it that you can't say about cross-examination or your experts? Like, it all seems so vague for an alibi defense.
Held through when the court vacated the rest of its scheduling order. So I don't think that we're foreclosed from that. And the court also has the ability to give an extension besides the limited time by statute. In this case, it's more than Brian was just driving around. We have let the state and the court know that we expect that will be supported by expert testimony and by cross-examination of the state's experts. I need their full cast report and the rest of the discovery related to that before I can say more about that.
Right, so, well, see, there's still some discovery that is not allowing me to give all of our alibi information, which is like, okay, I mean, I guess that's possible. But again, this stuff is a little bit of a semantics argument, in my opinion.
To tie me to a deadline when I don't have the rest of the discovery that I've been waiting for that would relate to that will mean that I will be back asking the court to reopen it. My expert can't finish until I get the rest of the discovery as well.
And the discovery you're talking about is a video of the car?
No, I
What do you
so the video that we talk about.
He's like, can we just speak English? Like, we don't need to be like vague about this. Can you just, I don't want to read between the lines. Just tell me what it is you're waiting for. Are you saying that there's going to be video or something of him driving around? Like, what is it that you're waiting for?
Is one that I think the state's going to use in its case that I don't have full video on, that I'm not talking about any video of Brian's car. When I'm talking about an alibi defense, what I'm going to, unless there's video that shows it elsewhere that I haven't gotten to yet, which may be possible given the fact that there's a lot I haven't seen yet. What I'm talking about though is the cast report, the drive testing information.
Cast report meaning the identification of the particular car.
That is the cell tower information. So what that is going to show and what the drive testing data is going to show and what other reports related to that are going to be things that my expert needs to finish our investigation and things that I need to formulate my cross-examination against the state's expert. So when I'm telling you that I'm going to do those things in Alibi, I can't tell you more than that right now, but that's how we're going to support Brian's alibi, that he was out driving that night.
Okay, so you're saying that you have not received the cell tower reports?
I have some data, some cell tower data, some phone record data. I have a draft of a CAST report. The most recent information I have, CAST is the FBI doing their work. The most recent information I have is that on March 31st, they expect for that report to be.
I do see some confusion in the chat with some of the questions about why doesn't he just provide his alibi? Where was he? Why can't you say where he was? He said he was out driving that night. So what he was doing is not a mystery. But how are they going to prove it? What evidence do they have to corroborate it? That's the mystery. That's what the state wants. And that's what the defense says they're still working on because they need more discovery. Their experts in cross-examination is going to bring out exactly how they prove this, which is like, fine. You can always do that. If a cross-examination question proves the alibi, you're always going to be allowed to ask that question on cross. It's not like they're going to say, well, you didn't tell us you were going to ask that question on cross, so you can't ask it, because that would prove alibi and that deadline has passed. They would never do that. Come on.
Done through the peer review process. So I may get it a month from now. I need to get it to my expert to digest. There's materials that support their report that I don't have full disclosure of. And the state's aware of it. I think they're working on it. And maybe they're on that drive that I'll pick up today, but I haven't had them yet.
So you expect to get that in mid-March?
I expect to get their report after March 31st after it's done. The supporting data, I'm not sure when it's coming. They tell me it's coming.
Okay, I'm going to kick it back to the state.
Your Honor, I guess I'm a little confused because if
Well, I obviously am too. So,
okay, I'm confused because if the defendant's alibi is that he was out driving around that night, I'm not sure what additional information his cell data could add to an actual alibi defense. It seems like what the defense is asking for, and they're being completely upfront about.
Why does she care? Like, that's what I'm saying. If I'm a prosecutor with this case and I'm confident, I'm like, fine, whatever. Give them the data, but just set the alibi defense the day after the discovery closes or whatever. You know, it's like, whatever. Like, who really cares? I just don't understand what the state's worried about here. I really don't.
It, and I appreciate that, but what they're asking to do is essentially double check all the discovery before disclosing their alibi, and that's not what the purpose of an alibi deadline is. In fact, it's quite the opposite. There is case law that describes that given the ease with which an individual could fabricate an alibi, and certainly that's not what the state is accusing the defendant of doing. I'm using language that is in case law, though. Given the ease with which
usually when they fabricate an alibi, I'll just say that's great for the state because they mess something up or there's something that disproves that alibi. So go ahead and try to fabricate something when he's already said that he was out driving. So it's not like he can fabricate that I was in Timbuktu or something. I mean, this usually when defendants lie and they try to do this stuff that they think is so smart and can outsmart everybody and trick everybody, it blows up in their face.
an individual can fabricate an alibi, that is a very legitimate deadline. It's a reasonable deadline. It's a reasonable demand of the litigation process. There is a reason why there is a 10-day deadline in the statute, and that is because the defendant is able to tell his counsel where he was that night. They can work together and formulate a defense, and they can disclose an alibi. That is the whole purpose of an alibi deadline. The state has complied with the discovery up to this point. We will continue to comply with discovery. We are disclosing everything that we have to the defense when we get it, unless there's some protective order issue. We are asking that the court hold the defense to a fair standard that has been set forth in the statute, and that is constitutional under the United States Constitution and the Idaho's Constitution that has been repeatedly upheld by the United States Supreme Court and the Idaho Supreme Court. Thank you.
Okay, I maybe dropped the ball, but went through the cracks that I didn't. I guess what I interpreted that as that was it for what we were going to hear about where he was and how he was established. The evidence that he was in a particular place. So once again, trying to be compromising, I'm going to give you until April 17th. You can submit the other.
He's like, sure, I'll give you a month and a half. I'll give you 6 more weeks, get as much as you can, and then provide it. Because it doesn't matter, especially if we're going to set this trial in June. The state's not prejudiced if they find out his alibi over a year before trial. Like, come on. Let's not start to act like you're being prejudiced, state. Defense, just turn it over. I think the judge is being even-handed, and he's kind of like laughing under his breath, like, okay, let's set a new deadline, June. Do it by then. State, you're not going to be prejudiced because of that. The state's happy because there's an actual deadline set. I think the judge is doing a good job of keeping the peace, trying to keep the case moving and pushing everybody, but not stepping on anybody's rights. And that's the most important thing for a judge.
Solutions that we can find for and that should be plenty of time because you're going to get some additional information from FBI apparently by March, and we can talk more about that later at the hearing on the motion for change. So that gives you some cushion. I'm not going to set it for 10 more days, but I am sending that. And the reason for that is so you don't have ambush at the trial. I mean, that's why that is established as law. Okay. Well, I think we've gotten somewhere.
A little bit.
And is there anything else we need to address today, Mr. Thompson?
I don't believe so, Judge. Thank you.
Okay, Ms. Taylor?
No, Your Honor, thank you.
Okay, great. Thank you all. We are adjourned.
All right. And that's the hearing. And I'm going to be quick here at the end because it's bothering me to see how the unstable internet is hitting the stream. Did he have his phone turned on that night? If not, why not? Should something at trial, yes, it'll come up that he did have his phone off. I believe at least that's going to be the evidence. Gringa, does it seem like the defense has some ace in the hole they're fleshing out? A lot of times it seems like that with the defense, civil defense and criminal defense sometimes, and then they don't end up having it. If they do, I'm sure we'll see it at trial. And Missy M says, does the judge have all the discovery? No. And at this point, it seems like the state doesn't even have all the discovery because the FBI hasn't turned it over to them. All right. I appreciate you guys so much for sticking with me through the annoyances and the frustrations and the freezes. Hopefully we get this figured out. I'm canceling this internet tonight. Going to get a new one as soon as they can come in. And hopefully that works out. Hit that like button. Make sure you subscribe if you haven't already. Until next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a pase you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.